Let's.
What do you have to say about that?
Yeah, they started the case of Asari Dokubo, which is not relevant, which was an application to enforce his fundamental. And the federal government said the right of one individual cannot be denied by state security. This is not the case here. This Court of Appeal has already found that the lower court was wrong in retaining 7 out of the 15 count charge. And so this court also dismissed the remaining 7 counts and said Nnamdi Kanu is discharged. Discharge means you have no case against you. A very responsible government, all they will do is to let that young man go home, particularly as we have shown in our affidavit evidence and document that he is gravely ill, has a heart condition, which a specialist doctor has said needs an urgent surgery. And they have no answer to his medical conditions. What they are doing, when they feel that his potassium level is too high, they either increase the dosage or decrease it. So they are just using Nnamdi Kanu as a guinea pig, trial by error. So we responded that there is no question of saying releasing Nnamdi Kanu will bring unrest in the southeast. As a matter of fact, it is the release of Nnamdi Kanu that will bring about peace and tranquility, not only in the southeast, but in the entire country. And I gave the court the example. When the court made its judgment or pronounced its judgment on the 13th of this month, the entire southeast went quiet with jubilation. They were drinking, eating, dining, and dancing on the streets for the next 3 days, 4 days, 5 days, from Owerri to Aba, from Umuahia to Enugu, from Onitsha to Abadan, from Umuchu, Ekulobia, Amesi, Uga, to Njikoka, from Abakaliki to Enugu, from Port Harcourt to Aba, everywhere. Igbos are happy and they are looking forward to this judgment that when Nnamdi Kanu is released, there will be peace in the southeast. 2023 elections will come very well. I thought, I don't know who advises this government. If I were the advisor, I would say, sir, Mr. President, let my people go. And with Nnamdi Kanu leaving prisons, don't forget, any day they hold him further from 13th of October is illegal detention. We are already going to court with the fundamental rights enforcement matter. So it is releasing Nnamdi Kanu that will bring about peace and tranquility, not detaining him. And we have also argued that the court cannot stay the liberty of a citizen. That was why we cited the case of Gloria Mowari versus Nigerian Army. Ulisagakova is my good friend, handled that matter. I was detained with Ulisagakova over that of April 1990. We were detained at Child Avenue, at the DMI in Apapa, near a toilet, with soak away, with maggots and human feces coming out so as to punish us. And in that case, Gloria Mowari was 7 months pregnant. She miscarried because of the traumatic and trauma, the ordeal, psychological, mental, physical that she went through. And when they went to court, the court said they should release her because she was discharged, just as Nnamdi Kanu was discharged here. What did they do? The federal government filed an appeal in that case against a woman who was detained under Decree number 2, under IBB, when the military was the military. And then they also filed a motion for stay of execution. 2 justices pronounced were very hard on the federal government. Justice Atukago, who later was elevated to the Supreme Court, and Justice Kolawole, Owolabi Kolawole. They said, you are asking the court to stay execution. It's like asking the court to stay execution of the liberty of the citizen. That you are a contender. And being a contender, you are slapping us on the face by telling us to stay the execution. Do you know how they put it? You see, it is like a sinner telling God that, look, God, I know I am sinning, but please help me. Aid me to continue to sin. He said, even God will not grant that sinner's request. He said, in that same vein, we, will not grant this request. This was the same Court of Appeal sitting in Lagos. And we are talking of as far back as 1992. What has changed? Ojukwu and Governor of Lagos State, it's clear. Governor of Lagos State versus Ojukwu, both the Court of Appeal and the Supreme Court, they made it clear that you can't be in contempt of a court procedure and come before us again asking for an equitable remedy, because stay of execution is an equitable remedy, which is based solely on the discretion of the court. He who comes to equity must come with clean hands, and he who comes to equity must do equity. You have not done equity. You are coming with soiled hands. That was why the Supreme Court and Court of Appeal said, you have thrown Ojukwu out of his Vilaska Lodge at Queen's Drive, Ikoyi. We told you, take him back. You refuse to take him back, yet you are coming before us to ask for a stay of execution. We will not grant.